Good afternoon, everyone, and welcome back to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. As you all know, or maybe you forgot because it's been a while since we've been live, but those of you joining us live this afternoon have the opportunity to ask questions and interact with our speaker. If you have a question or a comment or anything like that, please type it into the comment section below the video and we will be sure to address it. Episodes are released each week following the live broadcast, so be sure to hit that subscribe button and click the alerts icon to make sure you don't miss an episode. And below today, we have Gregg Luther with us to talk about bad faith litigation. Well, insurance bad faith litigation. I don't know if there's other bad faith litigation other than insurance bad faith litigation as it applies to us, but that's what we're going to be talking about today. This is a powerful tool that we can use to help our clients and to hold insurance companies accountable. I find if an insurer knows about bad faith and you just so much as hint at it, they get back on track real quick. So I know it's a tool that some of us have and others don't, and it varies throughout jurisdictions. If anyone is going to know about what your jurisdiction has as far as this goes, it's going to be the professor, Gregg Luther. So as we all know by now, Gregg teaches black letter law. He does the medical malpractice referring attorney program. We'll put a link to his website, his contact info. So if you want to talk to him about bad faith litigation after this podcast episode, you certainly can do that. Gregg, tell us, I don't know, what's new in insurance bad faith litigation, what we can do in it. Let's just get into it.
Well, hey, first of all, it's great to be back.
Great to be back.
Good to see you again. And here we are live again on the podcast. So
yeah, you guys, you did not see it wrong. We are live. Hello. Yeah. We are.
Well, it came out. I don't know if you saw this. The first blast they did came out that this was going to be a replay.
Oh, no.
And I was like, no, it's not. Because I'm going to be on there and I know I'm going to be live. So for everybody joining us live, thanks for coming. Jenna, thanks for all you do. This is a great tool for reaching out to everybody. And, you know, the greatest thing about this is it's free. It's free, and we try to give value-packed content here. So, you know, it's the great thing about, you know, Keenan Trial Institute is that Don shares a lot of this stuff for free because his main mission is to help. It's to help lawyers do their jobs well, and that's why we're here today. Bad faith law, insurance bad faith law is... You're right. It's venue dependent on where you are. But I'll tell you this, we wanted to get out in front of this because you know what DRI is doing at the end of the month? They're doing, you know, how emerging trends in bad faith, insurance bad faith. So they're you know, coming up with new ways to try and stop our clients from getting what they deserve. And we want to be out in front of it. So here we are. So the topic today that I picked is the top 3 mistakes that we make in bad faith cases, or just in working up a claim, you know, and then the mistake that we make so it's not a good case for bad faith. And I'm going to have to I got to give credit where credit is due. I know, Jenna, you know my wife, Diane. A lot of people know Diane. Diane recently retired from the insurance industry, but she, in addition to, you know, working and teaching in that industry and adjusting claims, she, for more than 2 decades, worked as an expert witness in bad faith claims handling. So insurance claims handling. So I see not only, you know, from the cases I've handled and consulted on, but from cases she has been on, where, you know, we talk constantly about cases. In fact, little we met. She was an insurance adjuster for Physicians Liability Insurance Company.
Oh, interesting. Gosh, you have like an insider's track.
So, yeah, so we we've shared everything as far as our professional lives, our whole careers, and our whole marriage. So much of what I'm able to provide is not just from the lawyer's standpoint, but from her standpoint of working as an expert witness on both the defense and the plaintiff side, and finding out the problem. So I'm using that information, that deep well of information as well that she provides. Now, you hit the nail on the head. What's the number one mistake that we make as plaintiffs' lawyers? We don't know the law. Mm-hmm. We don't know the law. Listen, do yourselves a favor. With the search engines we have now for legal research, you can search all your state Supreme Court cases in bad faith, insurance bad faith. You can research them all and read them in an afternoon or a day. There's just not, there's not that many. This hasn't been around that long. And so you can get all the law in maybe read and summarized so that you know it in a day, maybe half a day. And then there's statutes that apply, which is where insurance companies get by with heinous crimes at times, like, does this exclusion apply here? Are they allowed to do a step down here? Is this a resident relative of the household of the named insured, and does that negate a step down? Those kind of things. You got to know that stuff. I mean, you got to know it, you got to know it, you got to know it. So read your statute books as well. Now, good thing for most of us, most every state has adopted some form of the Uniform Unfair Claims Settlement Practices Act or the Fair Insurance Practices, whatever they've decided to codify. Most every state, and you need to know that as well. And in the statutes, we all know what's behind the statutes. Annotated statutes are all the cases. So just go there and you'll find a majority of those things. But you've got to know that stuff. The days. If you're going to be certainly working the Keenan Edge template for prosecuting cases, you got to know the law. You got to know the law, and you got to be right on the law.
And you got to do it yourself too. Read the cases yourself. Don't just rely on, maybe something that somebody told you. I have found that when even more seasoned lawyers who've been doing stuff for a very, very long time, sometimes they will say, well, this is what you can do because this is what this case says. Or this is what you can't do because this is what this case says. But then when you go read it for yourself, sometimes people forget or they misinterpret. Do it yourself. Get in there and get those cases and read them yourself.
Yeah. Well, and to really, jump off on that point, not your associate, not somebody else. Don't get someone else's brief or memorandum or whatever and think that does it for you, because it doesn't. Keep these cases nowadays. We can keep these cases in a folder on our computer, and we can go to them and read them. I've got cases I have highlighted to death because every time I have a new case, I go back and read stuff, and I find stuff that I didn't know was there. I wasn't reading it for that the first time, and now I'm finding new stuff. Mm-hmm. That maybe it's in a footnote, maybe it's in a all kinds of stuff. There's so many things. Does your state law allow for an insurance company to use a comparative or a contrib defense when there's willful reckless? It probably doesn't. So there's so many times, and listen, insurance adjusters are not lawyers. Very few of them know the law like they should. And insurance companies don't do anything to make sure they know the law. Now, there are some insurance adjusters who actually are law school graduates, and some of them, maybe practice law at some time. But they will still, one in particular, and I won't say her name or what company she worked for, but she was responsible for some of the largest bad faith verdicts in a certain state because she thought she knew it all, and and so she made some really big mistakes. She's not with that company anymore. I don't even know if she
cost them too much money.
Yeah.
Stop it, lady.
So you've got to know the law. You've got to know the law. Get your case law, get your statutes, especially if you're, in a state that has some form of the model, Unfair Claims Settlement Practices Act. Get that, know it, read the annotated cases behind it. It's good stuff. Then you got to know, when you get into the law, what are your elements in your state for a bad faith case? So these cases are, you want to talk about parallels with med-mal. These cases suck up your time and they suck up your money. There's nothing, it's not like just working up a car wreck claim and getting that settled. It's not like that at all. And typically you have to have all your experts hired, all the work done, and have a fuse burning down on a trial date before they even want to talk settlement. And sometimes they don't even want to get, they don't even want to talk settlement. So you're going to end up trying them. So you got to be right on everything once you step into this arena. And that's push pause for a second. The thing I'm most proudest of being part of Keenan Law Firm is we have, in the referring lawyer program, we take lawyers who have, maybe practiced in a certain area, but never stepped off into something like med-mal or, employment or these, arenas that require a specialized knowledge and a bunch of time and a bunch of money. And we take lawyers that have no experience and help them and their clients to, the largest payday of the lawyer's career, without ever having, prosecuted a case like this before, because, the great thing about the consult program is that we are with them every step of the way, but of the lawyers back home, on the curbside of things, they're getting all the credit amongst their colleagues and everything else, which, it's so rewarding, and the client's just elated with them. So, that's the beauty of being able to do this. And how do we do it? We're right on the law from the start. What do we do? What's the Keenan Edge template, Keenan Law Firm case prosecution template? First thing you do when a case comes in, research your law. First thing you do when you get ready to take a case, and I want you to do it. It's a mistake that many lawyers make in bad faith cases. I want you all to start doing it now. Get all your jury instructions together, or if you don't have pattern instructions in this area, some states don't. Get a set from somebody who has tried one of these cases. Go to the courthouse, get in the file, find where each side filed their jury instructions, and get those and research those. Research the case law in there. Prepare a set of jury instructions for the case that you are taking that you will ultimately give to the judge. And you'll be working on that set of jury instructions throughout the whole process. Throughout the whole time you're prosecuting this case, you may have a new angle. There may be some defense that the insurance company is trying to use that is not available to them with the right set of facts. So you can know the facts that you want in your case. And then next step is a timeline, just like, real similar to mid-mal. You got to have a timeline of when everything was done. Now that timeline better show that the client, the insured, or if the lawyer who was representing the client during the claim did everything they could to get the case settled, that were responsive, provided all documents. Don't be that lawyer. So many cases that we look at are not good, bad faith cases because the lawyer that was representing the claimant, the insured, did a terrible job, was unresponsive, didn't provide the documents requested. And I'm going to get into that a little bit because the insurance adjuster has a job to do. They don't start out with the insurance adjuster as your adversary. Start out with the insurance adjuster as basically your boss. What can I do? What do you need? I'll get it for you, because that's the best thing you can do for your client to get this thing resolved. No case should end up in a bad faith case, and certainly no case should be delayed or denied or underpaid because of crappy work of a lawyer. Okay, our job is too important. So those aren't cases. Take them off the table. The next thing that people need to look at is, is your state one of those that has the elements that have the, I'm going to call it a mens rea requirement, right? Criminal intent.
Yeah,
bad intentions, right? Some states have that. Like, it's basically a reckless indifference to facts and evidence that are saying, hey, pay this claim. And all they do is go out and look for evidence to the contrary. Dig, try and find anything, and anything they find. I mean, we've seen these claim files where anything they find, they try and twist around on, oh, she went out and hugged her horse, so her back can't hurt, that sort of thing. That's a real case. Those kind of things what do you think the jury thinks when they see video of surveillance of a private investigator that caught the woman with her walker walking out to the fence and hugging her horse when her horse came to the fence to say hi? It's not, but when, those kind of things, those are the, emotional things that really tick juries off. And this is an area for nuclear verdicts, because people, real people who pay insurance premiums and expect that when they need their insurance, it's going to be there for them. They expect them to pay just like they expect it to pay, in the case that's at trial that they're sitting on the jury for. So next little subheading under knowing the law is, do you have first party only, or do you have third party also? Some states have third party.
I would love that. We only have first party here.
Well, my buddies in Florida, where I, am, going to be moving soon, complained like crazy when they took away third party bad faith. And I was like, well, you still have the same bad faith that almost everybody else has. So anyway, that's just a little tidbit. But the next thing is a big deal, and that's, are you bringing a breach of contract claim as well?
Oh, interesting.
Because you need to know the law on this, and some of the things that a breach of contract claim will make relevant may help the insurance company out with defenses. But they otherwise won't get that evidence in, you know. So you want to investigate that and know, and does your state require that? Do you have to have a breach of contract before you have a bad faith case? And then if you do file it that way, is the court going to bifurcate it and make you jump through the contract hoop first before you can even get to the evidence that, you know, makes your case? So think about that. And I'm doing this, you know, some of you seasoned veterans may be saying, "Oh God, everybody knows that, Luther." Well, no, they don't. If you do this, if you make this a big part of your practice, you probably know a lot of the stuff. And I'll bet you, seasoned veterans, that you have made these mistakes that I'm talking about right now. And I bet you that you don't do them in every case. I bet you that a large majority don't do them in every case, and you have to make this your practice. You have to make it your standard procedure that you check all these boxes in every case, because a breach of contract claim, and really why I'm doing this is, you know, Don, in addition to being there for seasoned veterans, I mean, he's always been there for the puppy lawyer. Mm-hmm. He's always been there for the person starting out. And that's, I mean, we continue to do that. We have people in the med-mal referring lawyer group who have never filed a med-mal case before. You know, it's part of his purpose is to make sure that there's a place those people can go and get the training and, you know, work on their own case and learn these things and go through the process and come out the other end, you know, the local hero or you know, you'll be the person, hopefully, after you've been through the program, that the lawyers in your area call when they get that kind of case again, you know. The next thing is what area are you getting into? Okay, is it a property and casualty claim? Because you have to really know both sides. You have to know, you know, the underlying law on you know, what's compensable. Because what's an insurance company supposed to do? I mean, the contract's supposed to pay for a covered loss, basically the way the law requires it to be paid, or certainly, you know, if you're in a med pay situation, certainly then, even maybe auto. So you got property and casualty, life insurance, business insurances, CGL policies, you've got E&O policies, you got, which, you know, a lot of the med-mal cases where we get excess verdicts on doctors who don't settle, then that turns into an E&O claim. You know? Mm-hmm. So, or cases do settle. We had a case last year settled during trial, right before closing, because the defendant doctor was holding a sledgehammer over the insurance company's head and making them pay.
Yeah.
And they paid over the policy limits to get the case settled, and not just little money over the policy, big money over the policy to get it settled. So, you know, just like you were saying at the outset, these are not just claims that we file and prosecute a bad faith case. We also use them as leverage to get the right result, you know, when it should be. So anyway, the rest of that stuff, you know, MedPay, PIP if your state has PIP, and health insurance. Surprisingly, people don't think about health insurance contracts. And I know, okay, veterans, yeah, I don't know if anybody's watching. It could be just you and me, Jenna.
It might just be. I don't know. But
I don't get to see anything. But you know, when I watch these, it's always the replay on YouTube that I watch. It comes up in my feed, and then I watch it. So
yeah.
I don't know if anybody's commenting right now or not, but I get that health insurance, a lot of people's health insurance is an ERISA preemption issue, but you got to know that too. When we're talking about knowing the law, you got to know ERISA preemption because not all of them are.
Mm-hmm.
I've had a lot of issues with health insurance that on first glance looked like an ERISA preemption policy, and once you dig further, it's not. So, you know, you've got to be able to, you got to know the law. You got to know the law on all these things. I know this is dumping a load on people right away at the front of this, and I guess a lot of people probably, you know, click on to something else by now.
Yeah. Well, I hope not, because honestly, all of these things are really. I find when I watch a podcast like this, or when I'm sitting here listening to you, I'm like, okay, yeah, I got to remember to do that. All right. You know, and I always take notes, you know, with whatever guest I have on, but even if it's something, we do some bad faith law, not a ton of it, but some, and it's just nice to hear again, just like the steps to go through it. Oh yeah. Yep. We did that. Good. Yep. Oh shoot. I forgot to do that. Let me make sure I grab my jury instructions or whatever. So I feel it's nice to hear.
And screening on intake.
Yeah.
You know, on intake, you get a lot of this stuff flying at you, and you need to know everybody who calls, they got a problem, maybe the biggest problem in their life, maybe the worst thing that's ever happened to them. And they want to know what their rights are. They want to know what you can do to help them. I mean, that's why we're here. We're in the people helping business. Mm-hmm. If you're not, you know, get out, go do something else, because these people call for help. So, you know, on your intake calls, it's really important to try and figure out what you can do to help them and give them some advice, even if it's that you cannot help them or send them somewhere that they can. But obviously, you know, this is a lot of law to have to know. And, you know, those of you who have been around for a while know that anything Keenan is going to be, the work is going to be on the front end, right? It's going to be hard work loaded on the front end. So anyway, I hope this is helping somebody, and I can't, I'm trying to stop and, you know, make the points that I know the seasoned veterans are going to be raising, but I can't hit everyone because we're already at half an hour. So, and I'm not even halfway through. So,
oh my.
Let me keep moving here. Reason number two, okay. Mistake number two that we make. And this is not law, okay? So all you that stuck your fingers in your ears because you're sick and tired of hearing about law, this is not law. Lawyers don't know the claims process. So let me give it to you. Let me give you the steps of the claims process. The first one is communication. You know, it's like we do, intake. Get to know your claimant. What are the coverages? What policies did they buy? What endorsements were on those policies? That sort of thing. And then communicate. The first thing they have to do is communicate the coverages to their insured. This is a customer of their company. These are, you know, good hands, good neighbors, whatever they claim to be, you know, or just maybe funny people now, you know, on commercials on TV. I don't understand that, but they all seem to want to be silly and have silly commercials now. Or they want to save you money, you know, but anyway, there's some of the, next to, you know, maybe the pharmaceutical industry, the insurance industry is one of the biggest advertisers out there.
Definitely.
And they're spending tons of money on it. Well, they're trying to reach all these people. These are customers. Think of all the policy holders that they have that are paying premium. And if you're late on a premium or need a little bit extra time, is the insurance company understanding and good neighborly and good handsy? No, they're not.
Cancellation notice immediately.
Yeah. I mean, that's the communication that they give you. So people are sick and tired of that, But anyway, the insurance company, usually through the adjuster assigned to the claim, has to communicate with you. You know how it is now. I mean, it's text message and email mostly. It's hardly ever do you get a written anything. But what should be the parts of that communication? It should be the coverages that you have. They should be able to tell you real quickly if your claim is covered or not, or what the coverages are and what the endorsements are, which take away coverage. Insurance starts out with, the coverage that it provides and then starts taking it away. They have the blanket policy and then they take away certain things. Typically that's what an endorsement is, although not always. They should also communicate the claims process, what that's going to be, and set expectations, those kind of things. Our investigations should take how long, we're going to have these steps, we need these things from you. And then, the communication should continue through throughout the life of the claim. There shouldn't be long pauses. There should be constant communication both ways, two ways, Now, what the next step is the big one that all lawyers know. That's the investigation. The investigation of the claim. But that adjuster has a job. They're going to lose their job. They need their jobs. And this is, to draw an analogy to the hospital, to the med-mal arena again, just like the nurses aren't bad people, they're usually caring people to get overworked and underpaid and understocked and understaffed and made to do things that they wouldn't do if it were their family, basically. Adjusters are much the same. There's levels, hierarchies, way above them that decide things, but company policies that are going to determine how that adjuster has to act in order to keep their job. But largely, what they're doing during the investigation stage is not they're not pestering the client. They're not pestering your potential client or your client if you're handling the claim form. They're trying to gather evidence to do their job. They must verify. They must get the evidence and verify. Sometimes it's nothing. Sometimes it's just medical records. But we all know the lawyers that send in the crash report, collision report, and the medical records and bills, and expect to check the next week. We all that the adjuster can't do their job like that. They need to get statements. They need, depending on, what the company policies are, they have to follow the company policies. You be the adjuster's biggest helper. If you're the lawyer working up this case, you be the adjuster's biggest helper. And if they're stepping out of bounds, if they're trying to take a set off or a step down or something that they can't take because of a certain law that you should know, you tell them, can't do that here. That'll be evidence on the timeline if this thing goes south and they just refuse to pay. But the lawyer, who probably shouldn't be the lawyer prosecuting the bad faith case, should be a witness. That lawyer should be doing everything in their power to get their client's claim paid full value as quickly as possible. And that means helping the adjuster with the investigation, gathering evidence, verifying, all that stuff, getting that done. enough said about that. Everybody knows about the investigation stage. The next stage is evaluation, which is where companies go off the track a lot of times. They look at the evidence they got, and if is their mission to underpay? Is their mission to lowball? Is their mission to do as much cost savings as they can? If so, this is, in their evaluation, that's where they get slanted. That's where they start saying, well, she walked out with her walker and hugged her horse when he came over to the fence, so she's not hurt. That's where things go wrong. So how do you be ready for that? Your pattern jury instructions in most cases or your case law will say, give you all the categories of damages that are compensable, so it's real easy for you to know that stuff. And if they're making a mistake, you provide it to them. That's not, here's what we hear all the time. Oh, the insurance company got set up by this lawyer out to set them up. No, the lawyer tried to keep the insurance, the lawyer tried to enforce their client's rights. That's all they did. They tried to enforce their client's legal rights and contractual rights. That's all you're doing. If the insurance company doesn't want to follow it, if they choose to ignore you or lowball, then that's on them. You didn't set anybody up, so if you know they're doing something wrong, correct them or try to correct them. Those aren't, typically in the nuclear verdict bad faith cases, that's not the case, where the lawyer tried to correct him, or maybe there wasn't even a lawyer involved on the claim. So, and then the final stage is their decision making or determination. They got to decide: are we going to pay it? Are we going to, initiate settlement efforts? Or what are we going to do? How much are we going to offer? Those kind of things. And that's, where they go awry also. Now, in larger claims, a lot of times you see them engage coverage counsel, and sometimes that's where it goes wrong. There's some coverage counsel out there that try to do too much helping of the insurance company. Trying to find ways that they don't have to pay or to pay less and those kind of things, and that's wrong. That's wrong, but that's the world we live in. I mean, we all have seen those things. So that's the claim process. You got to know that to understand what's going on. So when you're communicating with your adjuster, well, how long, is the investigation period over? What did you allow in your evaluation range for, future emotional pain and suffering? Because typically they don't. They just give some number and they don't care about the rest. So anyway.
That's really fascinating about the damages portion of it. I think the times that we've had bad faith claims, it's always been just a blanket denial of coverage. And so we've just been working on that. I don't know that it's really interesting to think about a bad faith claim based on valuation of damages, because it's so subjective, right? It seems like, how bad does it have to be for it to be bad faith? It's really interesting.
Yeah. Well, there's a lot of cases where they've tried to pay a little or they've lowballed, and those, go read your state Supreme Court cases. And if it's not in there, get a state you borrow from, like California or somewhere, for you, find those cases that talk about that sort of thing, because underpaying a claim is bad faith as well. I mean, that's a violation of the duty to deal in good faith with your insured. We all call it bad faith, but the law actually, a lot of the courts have come around and calling them bad faith cases now. So anyway, we're in the home stretch now. The last final 20 minutes.
Yeah.
Good. Caught up.
Oh, good.
Now we're on to part 3, and a lot of people are probably going to be plugging their ears again. Part 3, the number 3 mistakes we make is that we plaintiffs' lawyers, the plaintiffs' bar, are not willing to do the hard work necessary on these kinds of cases. These are labor-intensive, discovery, battle, briefing issues. But where do you start, right? You got to start out with requests for production, that type of thing. So what do you ask for? This is exactly what we do in Med-Mal. What's your first set of requests for production supposed to look like? Well, you want a certified copy of the policy with all the endorsements and all the everything. Certified copy of the entire policy that this client, the insured, had and paid for. Another thing to ask for is the billing record, payment records, where they, make sure what you want to show in these cases, quid pro quo. Just
like the premium payments.
Yeah, in the Med-Mal arena, hey, I'm paying for peace of mind, or this person paid for peace of mind. They paid when the insurance company said you need to pay us. This person paid monthly, annually, quarterly, whatever. Every time for I don't know how many years, could be 18, 20 years or more, but whatever it is, they paid. You're going to want to have that in your timeline, and this quid pro quo. They're paying. They're doing their job. And the one time that they ask the insurance company, hey, pay me now. I'm paid for this right to have, coverage in case something bad happened. Now pay me. And if the insurance company jerks them through all the knot holes and, doesn't pay or underpays or whatever, that's, violation of quid pro quo. And I know that, I know that doesn't, complete your cause of action. Don't think it does. At least don't think by me saying that completes your cause of action. It doesn't, but it's a piece of evidence that you want insurance company at trial. Through all the knot holes. Who was in good faith? Who wasn't in good faith? Who acted in good faith? In addition to that, you're going to want all the claims, policies, and procedures of the company, all of them. And if some apply to, different areas, like if you've got a property and casualty claim and they have a specific set for that, and they got life insurance or something else with different set of policies and procedures, fine. But, be clear that you're asking for all the policies and procedures that are applicable to this claim, that the company has, all the policies and procedures of the company. Next thing is probably included in the previous item, but the claims manual. Almost every company has a claims manual that starts out, an adjuster is just not that much different than a lawyer when we get an intake. What is this? Now we got to put the pieces together. Well, the claims manual tells them how to do that. Wouldn't it be great if we had a claims manual for law offices? Or, I actually, before I joined Keenan Law Firm, I had a policy and procedure manual for my firm that explained all those things to do, because, every time there's a turnover, you got to train somebody new, and it's nice for them to have a written set of policies and procedures. Anyway, claims manual. Claims manual is going to be the guideline for the adjuster to follow, and there are a lot of good things in there for us. There's a lot of good things that they should be doing, and if they're not, that's good evidence for us.
Mhm.
The next thing, obviously, you want to ask for is a complete copy of the claim file. There's going to be a ton of correspondence and everything else in there.
Claims manual.
Nowadays, the guidelines, those things are adjusted electronically stored. So you want something in native format or something, with an audit trail to see when they went in and made what note, so that you can see when things were updated, what it first said, what it said later, those kinds of things. A lot of times you'll see an adjuster that starts off on the right track, wanting to pay a claim, looking for the evidence, thinking this should be a compensable claim. And then what happens? The supervisor says, no, we're not paying that.
Mhm.
Shave some money off of that. The next thing is you should probably not even do this kind of work if you're not going to request this and do the motion practice battles in order to obtain it. The personnel files of all the insurance companies, employees involved, every one of them. I can't tell you how many times I found in the personnel files the evaluation of that adjuster from the prior year saying you paid out a higher percentage on claims than anyone else in the office. So in order for you,
Anybody, please rein it in.
in order for you to get your bonus next year, your bonus is tied to profitability of the company. And so claim values have to go down for you. Well, how do you do that? I mean, maybe they just get lucky and they get all the little peon small claims, that they assign to them, but that's not the way it happens. I mean, they have to pay a claim what it's worth. And I had a really good case against one of the biggest advertisers that was just that. It was all about how they rake this adjuster over the coals she had to pay less. She had to find a way to pay less if she wanted a bonus. If she doesn't want a bonus, fine. You don't want a good bonus, fine. Just keep paying out more than everybody else. Well, there's no way to do. There's nothing in the claims manual or in policies and procedures that tells them how to do that. Do you think for 1 second that adjusters overpay claims? Can somebody tell me one instance where an adjuster overpaid a claim? Anybody? It doesn't happen.
Yeah.
It doesn't happen. You're lucky to get them to pay full value. You have to jerk teeth to get them to pay full value. But, on that point, you have to have some good evidence as to why your claim is worth more, And I'll just tell you, having worked with and know a lot of adjusters, they're not bad people. Mm-hmm. It's the system, it's the conglomerate that gets bad because they get all about profits. And that's how these bad faith cases, violation of the duty of dealing in good faith cases come about. So get the personnel files. They probably won't give them to you on first request. You're going to have to go through some meet and confers. You're going to have to, explain to them why you need these things. And of course, you're probably going to have to go to the court and, have a motion to compel to get these things. But you've got to do the work to get them. You got to do the work to get them because that is where your best evidence is going to be. Your best evidence is going to be, the policy, number one. You got to make sure there's coverage. Good Lord, don't get into a battle over whether there's coverage or not without knowing. Don't file that lawsuit. And then the claims manual, claims file, and the Holy Grail is the personnel files. Those are the things you need to be requesting. Those are the things you need to do the discovery battles for to make sure you get them. The next thing is real easy for us to go get. Pattern and practice, of the defendant, of the good neighbor. or the good hands or whatever, their pattern and practice. How many times have they been sued for this kind of stuff? You can go nationwide, really, because they're all nationwide, pretty much. They're on your side nationwide.
I just sang it in my head when you said that. Oh no!
Go do the recon on them and get all the dirty things that they've been busted on. And a lot of them have been hit for, huge verdicts, huge amounts of money on stuff. Go get that stuff. Those are your OSIs, okay? Those are your other similar instances that you can use, your expert can use, those kind of things. The next thing you want to have a good library on are the model or the industry guidelines or policies and procedures or textbook. There's a bunch of them. There's a bunch of them. When you see an adjuster and they send you a letter and they've got all these initials after their name, look those things up. Every one of those things that has initials on it, that's an industry organization that has their own publications about how to handle claims. Get those. You're a member of this organization, and there's some of these. There's some of them on the boards and committees that promulgate these things, and that's just drawing the same analogy to healthcare, med-mal lawsuits, just like ACOG has, all their honchos on their boards. These people that are promulgating these policy and procedures and these industry guidelines, they are figureheads at Allstate. They're figureheads at State Farm. They're figureheads at Nationwide and Progressive and Geico and all these things. That's where they come from. So the fact that they're, you open up the cover and there they are, the honcho from whatever, that really lends, some good credibility to that book of guidelines saying that's what should be done in this case, because the defendant's own honcho, cufflinks and Rolexes in the boardroom people, this is what they're saying should be done. So now, give the poor defense lawyer the hard job of saying, no, that shouldn't be done. Those are just guidelines. They should be violated at will.
They're just suggestions, just ideas, if you will.
And let me give you a tip on that, y'all. It's just like in med-mal. Listen, a doctor or a nurse or a hospital can violate a guideline if it means they're doing it to help the patient. If they're doing it to prevent harm to the patient or make the patient better, hey, Bubba is good with that. Why do they watch all these medical shows where the doctor violates the rules and poof, the patient's cured and the patient gets, the patient that had no hope is now going home from the hospital. Yay! We love that. We're Bubba too in that regard. But a doctor in a hospital and an insurance company cannot violate a policy or a guideline when it puts the insured or the patient or whoever in harm's way, where it hurts them. Can't do it then. So yeah, Bubba's okay with, insurance people climbing on the stand and say, we can't follow guidelines all the time. They're just guidelines. Can't follow them all the time. But you have to point out that, sure, you cannot follow a guideline if it's going to hurt the policyholder, or if it's going to cause harm to them or, mean they don't get coverage or whatever. Right, I'm with you, adjuster. But are you telling the jury that the State Farm tells you not to follow this guideline when it's going to hurt the policyholder, when it's going to hurt the company customers? Be sure to make that point.
Yeah, that's a really good point, because sometimes I feel like I get stuck on that sometimes, where they're like, gosh, there's so many rules, I just can't follow them all. And I'm like, yeah, you're right. You can't, you know what I mean? But that's a really good point of like, sure, we allow for that. We allow for humans to be human. We allow for doctors to use their judgment, whatever, if it's going to help that's an ends justifies the means that we can live with if it can help. But or the policy, maybe an adjuster allows coverage when maybe the policy had lapsed 24 hours ago. Or, there might be a thing that they violate that it's helpful, but not when it hurts. That's
right. And that's where, because Bubba's okay with somebody breaking the rules if it's to do something good, if it's to be a hero. Okay, you're okay there. So I'm nearing the end and I'm about out of time. So the other thing is get your experts involved early. Get your claims handling experts, whatever trades you need, your medical experts, whoever it is, get them involved early on board so that they can guide you along the way. Your claims expert's going to tell you how this claim should have been handled, going to tell you what policies you should have gotten that you didn't, those kind of things. They need to be involved early on. Don't hire them after you've taken all the depositions and the paper discovery's over and deadlines are running. Don't hire them then. Hire them early on. They can tell you the questions to be asking of the adjuster or the supervisor, et cetera, et cetera. And last thing that I want to drill into everybody's head is follow the Keenan Edge prosecution template. And that's, in the Edge books, you can go look it up. But first thing is get your jury instructions together when you take a case. Next thing, complete investigation, interview witnesses early, interview clients, record everything. Make sure you have all this stuff. Know your law, do your research, get everything you need, and then tempo. We have the upper hand because we have time to work on these cases before the defense lawyer even knows it's coming. We can get all the work done before we file the case, and then poof, here we are with, as soon as they answer, we've got requests for production, everything else. We want a scheduling order entered. We want to keep moving. I can tell you, I joined Keenan Law Firm before COVID hit. And then we had the COVID shutdown. And we had so many cases damaged because of the delay, because we couldn't continue. Clients died. Clients got worse. Memories faded, all kinds of things.
They got desperate and started wanting the settlement. So they
get fatigued. They get litigation fatigue and they just want out. They don't want this anymore. And the defense comes up with all kinds of things that, defenses they've created that they've gone out and gathered evidence for. Tempo is our friend, not theirs. And we need to have tempo. We need to prosecute our clients' cases timely and keep them moving. So, okay, I'm done. 1 minute left. So
awesome. That's fantastic. Good timing. Well, thank you so much.
Do we have any questions?
I didn't see any questions come in, folks. We have a couple more seconds if you want to throw any questions out there. I feel like that was super thorough, though. I mean, we just got so much information. I'm sure people were just spending time taking notes. I found the discovery stuff really, really helpful. Like I said, we don't really have too many of these, and it usually used it more as a threat than anything, but to know exactly what to get right out the gate.
Yeah. Well, think about that. If you're going to file a bad faith claim against a case that you were involved in the workup on, number one, you need to think about, how am I going to look? So you need to be, acting appropriately beforehand. Number two, think about how it's going to look when you request that claim file.
Yeah. What did you say? So Don actually said this to me early on, and he said, like when you write to defense counsel or Black Hat or whatever, or you write anywhere, just write as if it's going to be in front of the court.
Exhibit A, Exhibit B. Yeah, every correspondence is that way. And so it has to be tempered with, why are you doing this? You're doing this to help your client. Mm-hmm. You're doing this to try and get your client's valid claim paid as quickly as possible. And if you're writing the time-sensitive demand, write it right? Because that's exhibit one,
Yep.
To something, so keep those things in mind. It was good to see you again, Jenna.
You too.
We'll come back and do something else soon.
Yeah, we will. We will.
I'll be a stranger.
I won't. Thank you so much for being here, Greg. It's been a fantastic afternoon. And thank you to all of you who joined us live. We did have some live folks today. Thank you for being here. If you liked the episode, please click the thumbs up to feed that YouTube algorithm. Let them know that the content is interesting and helpful to you. Don't forget to subscribe and sign up for alerts so you don't miss an episode. We are going to be scheduling more live speakers here in the coming weeks and months. So keep an eye out for when we are live and you can hop on and benefit from the opportunity to interact with the speaker. If you would like to be a guest on the podcast, please reach out. If you want to hear from somebody in particular, please let us know. I am happy to set that up. So just reach out, let us know, and thank you for being here. Have a wonderful weekend, and I will see you next time.